This particular broadcast, we're going to be viewing and discussing uh, proceeding uh, of a case where the judge is bringing the attorney up on sanctionable charges because of his use of ChatGPT, and not just because he used ChatGPT, but he did not fact check to make sure that the information or the cases that were cited in the brief and in the preparation of the case, he was not knowledgeable of the case uh, enough to uh, how should I say, undo that burden. Because that is the responsibility of the lawyer to bear the burden of the research and fact finding and gathering evidence and so forth, so on. Now, he may pass that off to an assistant to assist him with that. So the use of the chat GBT was not what the offense where the offense occurred, okay, where he went wrong. Um, where he went wrong was he did not check to make sure that the information that was provided by the chat GPT was sufficient to address the court properly on behalf of his client. And so basically, this is a case of ineffective counsel that's being raised not by the the his actual client, but this ineffective counsel is being raised by the actual judge that was responsible to hear the case. She actually had her staff to read the documents, and they concluded that those documents were what they call unintelligible. Now, earlier I was watching a video of sovereign, uh, a person, an individual who was claiming to be a sovereign citizen, and you would see many times in the comment section people judging sovereigns who are trying to defend their right or represent themselves in court, and they don't do so well because they only have bits and pieces of information that they've gathered online, and they're not understanding the rules of procedure and so forth, with submitting the documents that they're wanting the court to acknowledge. Uh, but in that case, uh, you'll see, in those type of cases, you'll see the judges handling the individual very harshly, um, and they will even make fun of the person, and hackle them and so forth. Um, Not just the people in the comment section. I'm talking about, I've seen the judges uh, who have the nerve and the audacity to uh, not only degrade their authority uh, in actual, but they will post videos of them so-called handling this person and handling that person and how they're handling people. And to me, they're submitting evidence to their detriment online, because a lot of times they act under color of law, and they are performing violations upon the citizen, constitutional violations that they can then be uh, sanctioned or reprimanded, or they can have what do you call that? Create liability. They create liability on their own bond that they hold office, and they flagrantly um, post videos um, displaying behaviors that is unethical as well as unprofessional. Um, there's two judges in particular that I know is very popular for doing that online, and but there's a lot of different judges jumping on the bandwagon and placing themselves in harm's way as far as presenting evidence that they are violating constituents' rights to due process and so forth. Um, just because the person does not know how to properly defend themselves, that does not mean that they don't have a defense. And it's just unsafe for our society to be accepting of this type of behavior, or even condone this type of behavior, because the same people that will uh, gladly make comments and and hackle and make jokes about how stupid the person is that's standing up for their rights or exercising their rights. Um, they not understanding that they may encounter a situation in life where their rights may be violated, and because they're not watching to learn what is acceptable and what is not, um, and you'll see many of the uh, people who say, well, why didn't he listen to his lawyer? And why didn't he just let, or he or she just let the lawyer handle it? And this is stupid, and so forth and so on. Well, uh, they must not be aware that lawyers uh, have fallacies, as well. You have uh, lawyers that are incompetent, and this is a prime example of that. And you do see people in the comment section saying, okay, this is why I don't trust lawyers, and so forth and so on. Well, even if it was a sovereign saying, I don't trust lawyers, okay, I want to make this point very vital to making the best or wisest decision in any case. Um, Although you may not trust a lawyer, if you don't know anything, then you would have to rely upon the lawyer, okay? And in many situations, people default to using the lawyer, or the courts will override the person's decision to represent themselves and appoint them a lawyer because they have to. It's part of the rules. That part is not purpose to uh, rid you of your right. It's to make sure that you have adequate representation. Um, and so people need to learn how to get effective counsel out of the lawyer, how to use the lawyer, tell the lawyer what to say, what to do, what you need to know and be familiar with the aspects of the court and how things are done procedurally, okay? And the differences between jurisdiction and so forth, and probable cause, uh, preliminary probable cause, motion for probable cause is something that can be used to stave off an arraignment for, they say, oh, we just want you to say whether you're guilty or not. Okay, if you do not want to answer to that, the proper procedure to stave that off would be to submit documents requesting that there be a review of what's being presented to even make the case, okay? And so I think they call that a probable cause hearing, okay? What right did they have, or what they need to present enough evidence to show the court what they have that merits at least for the court to hear the case, okay? They don't need to have evidence. They don't need to have all their ducks in a row for a full-fledged case at that time. What they need is preliminary probable cause. In other words, to get it going, and to get an investigation going. Do they even have enough to get an investigation going to begin with? And so when people are asking for evidence in an arraignment, it's just out of place. They just so anxious to defend themselves that they're not understanding that there is a procedure and they need to pay attention to what that procedure is. Now, if you allow an attorney to represent you, you need to know when he's screwing up. You need to ask him questions, him or her. You need to ask your representative questions about your case. Well, what can we do about this? Well, can I file this? Or can I file that? And I even would go as far as, especially when you have a court-appointed lawyer, I would go even so far as to submit my own documents into the record, okay? And so that there is no mistake about what I want, because sometimes the attorneys will present you in a way to me like you're guilty already, and they just want to cop a plea. I was watching another case yesterday where the attorney was making an argument before the court that uh, the attorney uh, that was representing the young man um, uh, uh, encouraged him to uh, go to the attorney generals and um, try to work a deal with them directly in his particular case of homicide. And the appellant counsel was making the point that the counsel below uh, made the decision, and that was not ineffective counsel to counsel him to do that, because that's a common practice to counsel people to cop a plea. Okay, now the appeal court, the higher courts, is not really accepting of that, because of the fact that just because somebody commonly practices something, that doesn't mean that's the best option for you. um, Lots of people plea out, okay? Um, but there's people who know that they're innocent, and they throw that themselves at the mercy of the court or a jury to decide that. And they come out with better outcomes. So, and that's very common, that they come out with better outcomes than people who um, choose to uh, let a judge decide, or people who uh, choose a jury trial. Um, Many times get better outcomes. Um, I've even seen some of the uh, lawyers represent people on jury trial, and then now well, once I've seen the case, or come across the case, they uh, bring the case on appeal, and they lost, okay, with the jury. And so they telling the judge what all happened, um, that the judge was acting unfairly, wouldn't let them ask certain questions, uh, wouldn't allow certain testimony in, or wouldn't allow us uh, uh, witness, or suppress evidence, whatever. Okay, and 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 so that attorney would then have to uh, continue his advocacy on appeal. Okay, and when they go in on appeal, you can tell that they did a terrible job in the lower court, because the judge be asking them, well, why you didn't do this? Why you didn't do that? And why you didn't? And pretty much that is what's going on in this particular case, because this is a case on appeal. And so the judge is probably thinking this case is probably only on appeal because he's a terrible lawyer. What kind of effectiveness could he have at the lower courts? Um, and what type of effectiveness could he possibly be um, providing for his clients when he's doing some really what they call lazy attorney work? Um, that he's allowing the ChatGPT to do all of the work, and so all he's doing is basically showing up to do or perform oral arguments. If that, he probably even call in and reset and do all kinds of other stuff. People who do this, they have a pattern of unethical behavior, but I'm not saying that's his particular situation, but I'm just saying many times when people are incompetent in one way, more than likely are incompetent in many ways. So that's the judge's concern. Let's get it. Let's start the video. I just wanted to do a little prelude before we get going into this broadcast, because this is essential for people to understand. n- Not that lawyers are ineffective, but that lawyers can be ineffective. And so knowing your rights and understanding um, the procedures and what court is all about and what's going on and what's really um, the implications of these cases is very important, um, because people's lives are involved. Um, some people will say, "Oh, it's just a traffic infraction. Just pay the people and move, keep it moving." Okay. Well, the reason the people are fighting for their right is because they may not have the money to just pay that part. And so the only way that they could just pay is by doing jail time, being incarcerated. And if you've never been incarcerated before, then how you gonna speak for someone else who's fighting for their freedom to not be incarcerated, uh, to not be penalized in a financial way, to the point it's to their detriment, because they're already poverty stricken. You see people who are fighting cases in court for eviction and such. Um, Many of them are just following what somebody told them online. Well, who's responsible for that? The people creating false information online need to be, somebody need to formulate cases against them, because they do cause problems with when people believe them and try to follow their scripts and shit, and then they go in court looking crazy. And none of these people, these gurus, I ain't gonna say none, because I do know that, what's his name, Christopher Hauser, you know, he has stood in the gap with his constituents. Um, and if I'm not mistaken, he went down with some other people that they all was processing presentments and stuff. So uh, I do know that there are people who are really serious about uh, learning and understanding and reserving their rights. And they have a right to do that. And people have, they talk negative about the fact that he did go to jail. However, he's now out and free. And even while he was incarcerated, he was fighting his case from within. Now, there were documents that it was difficult for him to get to those particular documents because he was incarcerated. But once he was released from incarceration, he was free range to actively uh, pursue recourse. Recourse meaning, oh, you got me, but now I have a turn to do, you know, uh, throw my stone. He filed lawsuits on everybody involved, and I don't blame him. I don't blame him. They all thought they was going to get away scot-free. They refused for him to even testify in his own case. They refused to allow him to say anything or do anything or anything. They used pictures in the court, he said, to prosecute him and his co-defendants. And so, even in that case, what the lawyers did was unethical. What the judge did was unethical. And so um, they're experiencing some recourse at this current time for their actions, although they thought it was big and bad to do whatever they wanted to do. You'll even hear judges online in some of these cases say, I can do what one judge, he even cussed and said it's his fucking courtroom. He can do whatever the hell he want to do in his courtroom. He said he basically, I'm paraphrasing, but he's basically telling, and he was cursing and stuff. It was just unprofessional, and I don't see how the judicial community can uphold that type of behavior. Not, I mean, not with understanding that that breaks down the authority of uh, a fair and respectable uh, judge in their position. The position of authority is being undermined by the judges themselves. And so this is why you'll see a lot of people like David Wynn, and there's other advocates who go after judges specifically, because sometimes the lawyers are acting out of fear of the judge. They don't want to raise this, they don't want to raise that, they don't want to piss the judge off. They tell each other, oh, the worst thing you can do is piss the judge off. He's going to rule against you. Well, that's unbiased. And the judge has a responsibility and a duty to be as unbiased as they possibly can in any case. You're not supposed to drag your personal feelings into proceeding when you are the mediator, okay? But this judge is not speaking on her personal opinion of the lawyer specifically. She's stating, and she stated for the record, that her concern is about the clients that he's representing couldn't. I mean, it would be safe to assume that they're not receiving effective counsel. Okay, so let's get it. I'm gonna start it over because I've been watching it a little bit. I'm gonna let y'all get in on the action. Let's go.
You filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you filed with the court. Cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And, Mr. Gillespie, None of the cases made sense. I have a concern,
Sure,
and I feel that as it is my responsibility, I probably will have to share this with the bar. And Ada Molina Costin Cruz versus Darius Nellums.
Yes, Your Honor, this is Liv Kennedy for the defendants.
And Tristan Gillespie for plaintiffs.
All right. So, Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
Oh goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. So, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name.
Neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure, I'm pulling it up right now, Judge. Bear with me 1 sec.
You could be approved for $39 per month, full coverage auto insurance. The only catch is that you need to have 0 DUIs in the last 5 years. Drivers with 0 DUIs in the last 5 years qualify for...
Right now, Judge. Bear with me 1 sec.
We been with you, baby.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as a Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on 1 second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193, 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, something just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case, 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company. I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersions. I'm just telling you, he's been suspended in Maryland. And
Hold on. Where is he?
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr. Gillespie, I'm a former staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI, research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second-generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You've got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me. You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to provide additional briefing copies of the cited cases. Whatever.
I trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if 2 lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized, so I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It's more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court and the contumacious behavior is written in written form before the court.
Right.
So.
Oh, wow. She said the evidence is already on the record. That's what she's saying. He submitted evidence already against himself. She don't need no more further examination of anything to go forward with the sanction. Okay? That's what she's basically saying in legal terms.
I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like, literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. At the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. All right. So, Mr. Kennedy, I did ask you for your suggestions, any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct?
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay. Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction.
Why she on
And
the
so,
phone? They had to take
based
her
on
ass
that,
off the damn thing.
what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time. You're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston-Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston-Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
Waiting for Tristan's iPhone.
All right, don't know what that
Go
was.
ahead, sir.
Yeah, all of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed, and it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's a written document submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And, we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said,
Okay, now we get to the point that I was making before I began the presentation. That it's just a common factor, and it seems like it's not consequential, but when a person has created a pattern of incompetence, it's safe to say that everything they do is incompetent. And so here we have the evidence of that. The man is speaking and saying he's not responding to discovery, requests for discovery. He's not doing any damn thing. He ain't writing his own cases. He's not doing nothing but showing up in court with this arrogant attitude, moving right along. You need to be thinking.
Nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing or just oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolves all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further. But I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say.
What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing, just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. And so at this point, I'm not inclined to dismiss the case because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston-Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, $25,498.08. That's fees and costs.
And you said 8.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am, and then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Do you want to know how people are making $2,000 a month from rental properties they don't own, don't rent, and have never visited?
That fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court and in this case, so I'm not going to nitpick at this point. I feel like from the outset of the case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
Well,
I have another question.
Yeah.
I was gonna hire William and Michael, and I was gonna go Tuesday.
Oh, that's fantastic.
You don't think you could set it up for Tuesday? Because my brother's he's in the army. He's trying to
call him and
he's
find
trying to
out.
change my
You
life.
should definitely hire that. I'm sure they're a lot better than I am.
Yeah.
He usually he told me either to call me. I call him right now.
Yeah, but not up here. Just walk outside and do it, and then come back and find me.
Yes. All
I
right.
strongly encourage that, Judge.
Okay. Mr. Mauer.
Judge, he wants to hire a lawyer that they found online, Mr. Dismissal.
Oh, okay.
Yes. Over 99% DWI cases resolved without trial, which is he wants to hire this lawyer. I am perfectly happy if he wants to hire somebody, Judge. I'm sure this lawyer is much more qualified
John Vargas? Okay. Miss Ferguson?
So there are some file issues
upstairs in the DA's office. They found my other file. I'm conferring.
Vargas, come forward.
Against the person?
I was going to see if we could recall it for tomorrow. I can't come back this afternoon. I have to pick Rachel up at the airport.
Oh, how's Rachel doing?
Great. She's going on spring break, so she's going to swing by, pick up money, and go on spring break.
Yeah, I'm just springing by to pick up money.
Yeah, that's about it. Yeah, she's doing well though. Straight A's.
Oh, that is
She
awesome.
doesn't get it from me.
Oh, to be young and free again, right?
Yeah,
Just coming by to pick up money.
that's about it.
But usually they don't say
She
they're.
doesn't put it that way.
No, it's like, hey, how y'all doing?
Yeah, just want to see you because I love you.
Yeah. All right. So do you want this recalled for tomorrow?
If we could, Judge, just so they can find the file.
Okay. All right. We're going to recall it for tomorrow. Once you sign the reset form, you excuse and make sure you're on time tomorrow. Okay.
Yes, ma'am. I have another question.
Yeah.
I was gonna hire Williams and Michael, and I was gonna go Tuesday.
Oh, that's fantastic.
You don't think you could set it up for Tuesday? Because my brother's he's in the army. He's trying to change my life. You know.
Okay. So when are you asking for it to be set?
If you could try to set it for Tuesday, so he could do the approval thing, and then at least drop.
Wait, set your case for Tuesday?
I mean,
What Tuesday is he talking about? Tomorrow Tuesday or next week Tuesday?
I would have to call him. He had told me after I get out of court, call him and then tell him to Stephanie that I was going to hire Williams and Michael. So that way,
Make sure you want to call him and find out.
You should definitely hire that. I'm sure they're a lot better than I am.
Yeah.
he usually he told me he's gonna call me. I can call him right now.
Yeah, but not up here. Just walk outside and do it. And then come back and find me.
He
Yes.
seemed like he's special.
All right.
I strongly encourage.
Why they trying to try this man? He seemed like he's special needs or he was drunk. One of the two. Bless his heart. Bless his heart. But anyway, moving right along. I thank you all for joining me. We're going to do a short review of Chris Hauser's court case. Let me see if I can find it right quick. Okay. Okay. Here it goes. Okay. Now, before I click on this, I want to give a little prelude to that. As I stated before, people are very critical of sovereigns exercising their rights or attempting to do so. We want to criticize, but we want to add some constructive criticism to help people understand where they're going wrong. Okay? Let's do that.
Won't be a need for it personally.
No, wait a minute.
I am the beneficiary.
Exit, be a little quieter.
Yeah, I understand, Your Honor. If it would pleasure the bench, my name is Christopher Allen Colon, family of Hauser. I am a sovereign. I am a son of the Most High. A sovereign according to the Tennessee Constitution, Article 1, Section 31.
One question first. Did you want to reserve any time for rebuttal?
I don't believe I'm going to need to rebut. I think by the end of this argument that I have, there won't be a need for it personally. I am.
Okay, nah. This him refusing to want to reserve a time, a short period of time for him to rebut any statements. That was a bad call. Very, very bad call. And the reason why that's an extremely terrible call is because that time is reserved for you to do one of two things. Either readdress your points before the court and make sure that's fresh in their mind when they make their, go forth to make their decision. But it's also a good opportunity to state any objections. If the person was trying to interject some hearsay or anything, you don't know what they're about to say, just like she don't know what your opponent doesn't know what you're gonna have no clue what you're gonna say in your oral arguments. They're only familiar with what you wrote in your brief. Now, I don't know what in the world he wrote in his brief. I doubt if it was sufficient. Because the points that he's making I was going to make before the court. I've already seen this video, obviously. But the points that he wanted to make before the court are out of place. If I'm not mistaken, this particular hearing is on, the judge said he wanted to address a violation of his constitutional rights of some kind, but because he did not present any authorities, he's gonna present some authorities, okay? And he may have had that cited in his brief. I'm not sure. There was no posting of what the results of this case was, but I'm sure that the court had findings against him. And it was more procedural than anything because he did not present his case well. We're going to get into it and discuss it as we go. But first things first, he screwed up with, I don't need to rebut. I got this all sewed up. Once you hear what I got to say, you're going to rule in my favor. I have enough information to rule in my favor is basically what he's saying. It's good to be confident but not appear to be arrogant. Let's start there. And to me, there was an air of arrogance in his tone that was relayed in his demeanor and his tone and his rejection of the court practice, common practices of the court to reserve some time for rebuttal. Because this is not a case where you can cross-examine and so forth, and so that is the procedure that is utilized to formulate a cross, all right, and give him the opportunity to have the last say-so. And so if you have a case where you feel you are competent enough to represent yourself, then I think people should act accordingly. If you feel that you're competent enough to represent yourself, represent yourself. We shouldn't be able to tell the difference between a sovereign and a lawyer when you get up there. He didn't say who he was representing. If he's representing himself and others, he should have stated his name for the record. However, he gonna put it with colons and all that shit. At all. Meaning he represent himself and his other co-defendants, because he's gonna be wrapping off a lot of hearsay concerning that. Not understanding, that's hearsay. Without providing the court with any adequate amount of evidence to substantiate its claims, it's just hearsay. Okay? So, just because the court is listening to you, that don't mean you're being heard. What I mean by you being heard, in other words, it doesn't mean that what you're presenting is acceptable. Okay. I've generally known that the judge would question you. Well, why you think this, or why you think that, or why, what is you talking about? Okay. And then the judge is gonna ask him to clarify his claim, but he's unable to understand that he have not done so. That part. Because you will see, as this proceeds on, you won't understand what the hell he's talking about, or what he referring to, or what is his purpose. He said he just wanted to be heard. Okay, well, you was heard, sweet. You didn't want to win or nothing. You just wanted to be heard. Okay, well, they heard you. And they let him talk, but hearing him out is not the same as letting you talk. And so he just used the court to vent how he feel about some shit. Well, he should not even brought that before the court, just to voice and vent how he feels. That was a waste of the court time. And then he also seemed like he just doing this for the purposes of getting attention on YouTube, because he mentions the YouTube too many times. Like he's a avid YouTuber and this and that, and how many views the video got, and all this kind of stuff. Well, He may not be aware of it. He may or may not be aware of it. But a lot of times people are careful about how they handle certain people. If you have power or influence, they'll be a little more lax in how they handle you on camera. Okay? So, like I said, the judge is listening. But I don't believe he has presented a case that can be heard because he has not stated his claim for the record. What is your claim? What's your claim? What are you recommending or asking the court for? And so the judge asked him, what do you want us to do? And he said, I just want to be heard. Oh, wow. Wow. Well, anyway, moving right along. If we haven't gotten to that, I'll let y'all hear the shenanigans for yourself.
Beneficiary at all, appearing specially, in propria persona, not pro se. I'm sure juris and the beneficiary of the Social Security Sesticate Trust, the all caps name Christopher Allen Hauser.
Are you the defendant, Christopher Allen Hauser?
I would be Christopher Allen, the beneficiary of the all caps name.
So that's a no or yes?
I would be, you would consider me, the state would consider me as the defendant.
Okay.
Okay?
Go ahead.
To answer your question, there's one question I do have. Does this court recognize and adhere to the decisions made by SCOTUS? It does. I assume you're acquiescing, so. If so, the United States Supreme Court declared in 1969 the ability to place a lien upon a man's property, such as to temporarily deprive.
Okay. He's asking that question. It's a way of recommending the judge to ask about what guidelines govern them. If you ask any questions about guidelines that govern them, do they take an oath? Do they uphold the Constitution? Anything about do they adhere to the treaties and so forth? All of that is a line of questioning and that's many times received as an attack. He aimed and fired, all right? He saw that the judge was trying to demean him, so he aimed and fired at him with a legal a question that confines the judge to act accordingly. And so, like I said, they can listen sometimes, but that don't mean they hearing you. He's thinking of a way he can get you. He ain't thinking of a way he can help you. You done postured him to protect himself from any attack on his person. When you have filed cases against all the lawyers, the judges, and the police officers, everybody involved, which that was very smart for him to do that. I mean, not smart, but courageous. And to keep them from just continually, because sometimes when they come for you, and they put him in jail already, they will continue to harass you and try to find charges on you for different things. And so you got to nip that in the bud. And the only way you can nip it in the bud is to go for them, go for the jugular. And but I did, that's the reason I retracted the compliment of saying that he's smart, because the action of filing the cases was a wise and strategic move. Okay, however, if they throw out the cases or if they dismiss him, a great deal of them, because it was not prepared properly, that can lean the other way. In other words, that can make the people he went after say, oh, he's insufficient. He'll sue, but he's insufficient to win. He doesn't have the confidence to win, and he refuses to get a lawyer, so we can pin him up and railroad him, you know, and they plot to do that. And so we don't know what type of recourse he may experience from that. From losing. You don't start a case to lose. You start it to win. And he has the components to win. He's not presenting that very well, but he does have the components to win. Let's hear him out. He's doing the best he can.
Him of its beneficial use without any judicial determination of probable cause dates back to medieval England, but also to Roman times, unquote. That's Snydash versus Family Finance Corporation. According to this decision, there is no need for legal basis per Tennessee Code annotated 39-17-117. A1, where it states, when such person has no reasonable basis or any legal cause, unquote. But we did, however, go the extra mile to create the reasonable basis and legal cause. Evidenced by common law contract created via the postal rule. This contract is referred to as the conditional acceptance. You'll find that as Exhibit A for ID only in the case. That's the contract. The next point I'd like to get to is the withholding of exculpatory evidence. We did, in fact, have a valid contract with the legal victims by the states interjecting themselves in the middle of the contract. This would be considered interfering with the obligations of contract, which would make this a Brady violation, Brady versus Maryland. Along with the controlling case for Tennessee is Tommy Newley versus State of Tennessee, Supreme Court at Jackson. In the transcripts, they start at page, the court transcripts, the hearing transcripts. They start at page 603, line 12. The jury exits the courtroom. Then there's a conversation between the alleged defense attorneys and the prosecution for the state and Cheryl Blackburn, the judge of Division 3. If you read that, 603 through 605, you'll see that they discussed removing the contract from the out of the sight of the jury. This is considered withholding exculpatory evidence, there was two things that they marked for ID only, Exhibit A and Exhibit B. Exhibit A is the contract. Exhibit B is the affidavits that the public officials filed, removing the UCC ones off of out of the state's record. This law came about because of what we did in the winter of 2017.
And did you have a security agreement with these public
Yes,
officials?
we did.
And they signed it?
They signed it. If you understand the postal rule, when you send something certified mail, return receipt, the little green card comes back that is the signature card.
Well, I understand a contract requires a meeting of the mind. Did you have a meeting of the mind that this was a security agreement?
Yes, it was. And the security agreement, the state continued to call it a lien. And the UCC1, if you guys remember, if y'all remember the case, you heard it. If you go back on your YouTube channel, there were 10,000 views on that hearing, 40,000 on the Supreme Court case. I'm a viral YouTube content creator. So they signed those sworn affidavits saying that they had no contract, but in the affidavit, they speak about the contract. They did that in the summer, roughly, in the summer of 2017. Then they came back in 2018 and testified they had no contract. But they read the UCC1 filings that said, under common law contract number, blah, blah, blah. Every one of them. Every one of the witnesses, they either said they had no contract or they got something in the mail, which is the contract. According to the postal rule, when you send me a summons to court, you send it certified mail. I agree that I'm going to be there when I sign that. That's why they send stuff certified mail. That's you creating a contract with whatever court is bringing you in that you agree to show up. If you don't show up, they rule in favor of whatever. In this whole situation that we have, they withhold this. They signed sworn affidavits. And then they turned around and committed aggravated perjury, every one, including my ex-wife. I'll get into that. So that's our argument on withholding exculpatory evidence. That's evidence, I'm sure y'all know, that's evidence that may or may not have vindicated us.
Did you raise that on direct appeal?
No. I didn't raise anything on direct appeal, and I'll answer that question just briefly. The other issue is severance. We filed post-conviction. I filed post-conviction on behalf of myself et al., the rest of the guys that's in the group. I sent them, I mailed them out via the postal rule from Newport, Tennessee on the 9th of May. I sent one copy to Jonathan Skermetti. He got his on the 13th of May. I sent one to Cheryl Blackburn. She got hers on the 15th of May. The one that went to Joseph Day was, this is, and it should be in the record, this is the signature card that he signed. If you'll notice up here in the corner, the date's been changed to 5/16. I've got friends, I'm a veteran, I write claims, help veterans get benefits in East Tennessee for the Department of Veterans, the DAV. I've showed it to guys that they're retired military, retired postal worker. Hey, what do you think of this? Oh, well, they've altered the date. That's where we were refused post-conviction relief at. When the severance, they lack jurisdiction. The motion to sever during pretrial and throughout the trial were denied, according to Tennessee Rule, a criminal procedure, Rule 14. Severance is part of pretrial procedure. The trial court denied all motions for severance during the pretrial procedure for convenience purposes. Furthermore, according to Rule 14, there must be a request from one of the defendants for the trial court to even consider severance, severing one defendant from the other. If there was a show of the motion submitted by Lee Cromwell requesting severance because Cheryl Blackburn sent a notice to this court that she wasn't going to look at ours because we were 1 day late. And in that document, she admits that she's 9 months late reviewing it, and that we didn't file in a timely manner, but Lee Cromwell did.
That's called unclean hands.
Even if this shenanigans in the Postal Service, and there is an ongoing investigation with the United States Postal Service Office of Inspector General on this matter. I haven't heard the results of it yet, but this isn't right, what happened. We should, even if it wasn't, say it was a month late, it still should have been considered as an amendment to Lee Cromwell's, because we can't be severed. You can't sever after the conviction, according to Rule 14.
Remind me again who Lee Cromwell is.
Lee Cromwell he was involved, during this time, he was involved in a vehicular homicide in East Tennessee.
Wait. Now, why is he arguing against severance? Severance meaning they had mutual co-defendants, okay? Meaning they all was being charged for the same crime at the same time, same occurrences of whatever they was being charged with, and so they indicted them together, okay, all together as a team of people that was performing these acts together, and they prosecuted them all together. Now, one of the gentlemen, I don't know if it was before they got prosecuted, or he already had a running case against him and caught this case. It's not clear to understand what the hell's going on, the way he explaining stuff and he jumping. I know how that feels when you want to get it all out and kind of jumping back and forth. So it's kind of difficult to articulate what happened when and why does this matter when you do that. So it's good to have notes to follow along. The path of how you're going to present your case. I did mine off the top of the dome too because I wasn't all the way prepared, with understanding that I needed to have some notes so that I could express my points that mattered the most, because I didn't know which points that mattered the most. All I knew is that the court that was handling my case did not have proper jurisdiction, and so I leaned on that. And I also knew that the plaintiff had made a false claim. So I leaned on that aspect and impeached him to prove that, and so I won on that aspect. But I didn't cite any cases or anything. What I was citing was rules of procedure, because my appeal was on procedure. And he made his claim that they did not follow procedure. However, he did not point out all the aspects, because there was several procedural errors that occurred, but he's fixated on the documents that I don't think he properly prepared himself to point out the constitutional grounds for his case has more validity than the details. The action is what creates the violation, true enough. But he's giving some details that's irrelevant, that's not helpful. For example, the judge asked him, did he address his concerns for the violation of his due process? Did he address that? And he said, no, I'll get to that. Instead of addressing that, when the court is consciously attentive to hear his response. That was a bad play right there. He has built a rapport. Seems to be he built a rapport because he was presenting his case what he started out his opening statement was very good, I think. Other than his long drawn out name and declaration of the SANTIONABLE. Because the SANTIONABLE, it doesn't even have anything to do with this, okay? Well, you could tie that in, but he didn't do a good job of tying it in. I believe that the mention of the SANTIONABLE should have been reserved for mentioning that once he got into the facts and how he was handled, then he could declare that he is being held in trust, okay? And so, that shows the relatability when you stating your facts, okay, they handled me this way and that way, and I am the beneficiary of the trust, that they're making claims on the record to have handled the matter concerning me to my benefit, and it was to my demise, okay? That would be the time to articulate the protections of the trust, okay? Declaring the trust, okay? That would articulate why he's declaring his declaring the trust. Even if he had started out with that would have been fine, but he needed to explain why was he even declaring his state of trust. Okay? The hearers wouldn't understand if they don't know anything about the certificate law. That's the reason why you see people judging sovereigns and saying, oh, they sound stupid. What is he talking about? And da 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 da. Because they're ignorant and they are not, they're unlearned. And so they don't have no clue what he's talking about. And so they think he's stupid for even saying it because he didn't clarify himself. Anytime you want a contract, he's before the court trying to contract with the court right now and don't realize it. Okay? You're trying to contract with the court. Okay? And like the judge said, I understand how contracts work. I'm sure he wanted to say, do you? Because there has to be a meeting of the minds. And in order for you to enforce the nature of the contract, there needs to be a meeting of the minds, or a written record of acquiesce. Okay, acquiesce means you agreed, but you didn't say you agreed, but you didn't say you disagree. All right, you didn't send a rebuttal. You didn't say, man, I don't owe you shit. You know. We send you a letter saying you owe him $1 trillion, and you send him an angry letter back and say, I don't owe you a motherfucking thing. Stop writing me. I don't even know who you is, dude. Instead, they either ignored him or they sought action in what they call that? Malicious endeavor to conspire against them. And if I would just say, in my opinion, he didn't have a contract. Okay. Now, he's purporting that some other people agree with him that he has a contract, but I wouldn't have agreed with him. He didn't have no contract. I don't think he took enough I don't think he followed the proper procedure to meet the burden of proof that he has a contract in place that is what they call that? Either it's void or it's shit, what's the term for that? Enforceable. Okay. Enforceable. Okay. Either contract is voidable or enforceable. And I think he had a contract that he could enforce, okay, but he didn't. From my understanding, I don't think he followed the proper procedures to enforce the contract or to have a legal right to lien based upon that contract. place a lien of indebtedness. Say this person owes me $100 million. Okay, so after he leaned on them, he sent it to the U.S. Treasury. In the U.S. Treasury, he told them, okay, he created a contract with the U.S. Treasury and told them, hey, if you can collect on this, I got some people owe me millions of dollars. If you can make them pay up, I'll give you 35%. I think it was 35% of the whatever proceeds you can collect out these motherfuckers. And so he tried to turn the IRS and the U.S. Treasury and the state comptrollers, he sent the dogs after them. But when he sent the dogs after them, they turned the dogs on him and said, we don't owe him nothing. This man is crazy. He's not the only one sending us these wacko letters. That could be considered as terrorism, paper terrorism. And he talking about some ruling came about because of him. I don't know why in the hell he's so proud of that, because I don't know what he talking about. The judges don't seem to know what the hell he talking about, and he didn't make himself clear as to what he talking about. He's responsible for them making up a new rule. I reckon they made up a new rule to put people in jail for the same activity that he is predicated of all these officials. Because he be down there at the courthouse fucking with them people so much. I admire his courage though. He's amazing. But he has that, it seems like arrogance, but I don't think he's arrogant at all, really. He may come off as that, but I think he's just very confident and sure of himself sometimes when he should not be so confident. Because he might be wrong, or he might not got all his ducks in a row. Sometimes he don't have all of his ducks in a row before he start growling and biting. Okay. You know how some people don't. Today I was walking to the store and these people, they done train their dog to be racist. And he don't even wait for the nigga to come down the street. He run out the yard and go chase the nigga down. I'm the nigga he chased down. So I know in fact this is going on, all right. And I had a stroller like walker thing, and I used that to guard myself from him being able to get me and nip my heel. But you can tell they trained him to do that. Try to get you, bite you. You think he a small dog, but he gonna come after you and he gonna bite you. He gonna bite you before you realize he done even claimed up on you. Okay? And so he done trained, Chris done trained himself. He's a doer, okay? He ain't gonna be he ain't gonna be like other people who get wronged and he don't do nothing about it. He gonna take action, all right. He gonna take action against that ass. He military, and he ain't beat for no bullshit. He feel like, hey, I done served this goddamn country, and I don't appreciate that. I done fought for other people to enjoy, because that's what all the laws is about: enjoyment, and the pursuit of happiness, enjoyment. All right. All the laws around buying property, contracts, this and that. It's all about enjoyment, about you enjoying life, period, all right? And he don't appreciate nobody interrupting his enjoyment, so he will take action. And that's a good thing. I commend him for that. I just think he needs help. Sometimes people want to be the leader, but they don't have the capacity to lead in that manner. And so, if everybody else around him is afraid and saying, oh no, I don't want to be involved in that, I'm too scared to be dealing with them. Them the feds, man. It's whatever their fear is that prevents them from assisting him. It is what it is, and that's the same lack of confidence that stops people from defending themselves. Of course, it's not going to allow you to have the wherewithal to stand in agreement with someone else. Okay, people probably figured, hey, he didn't already caught a case behind this shit. I don't want no parts of this. And his wife he tried to keep his wife out of his shenanigans, which is fair, because she don't need to be involved in all that, because that's something he want to do. As far as he's very what they call that? Litigatory. He like to litigate some shit. Now, he drafted all these documents to enter into contract with these people and so forth. Well, my question is, and maybe he just didn't think of it at that time, but my question is after the fact, why didn't he just, if the U.S. Treasury is in agreement with you, modifying your documents, why couldn't he just set up a private interaction with them to do business with them directly, just like the banks do? Or have an intermediary, a go-between. Write them a letter and ask them, if I can't deal directly with you with processing these instruments, well, can you make a suggestion or a referral or refer me to a broker or whatever I need to do so that I can process my notes? Okay? When he's trying to create bonds and bills, and he could have just created a note and sent it. So what do you need this money for? If you're asking for a bunch of money, what do you need this money for? I think I did overhear him one time say that they tried to take his property, his house, his home, or something. And so he needed to me, I wondered, like, why didn't he know so much? But it's like the real pertinent facts or understanding, it just eludes him for some reason. It's like, okay, you understand how liens and stuff work now, even from the bad experience. He obtained some more knowledge from that based upon that bad adverse consequences. To not knowing, hey, you can't do this. Okay? Now, I don't even know at what point did they decide to bring charges against him because he's so aggressive. They probably tried to let the shit go, just like the judges tried to allow him rebuttal time. He refused that. The judge tried to ask him about a statement he made that's relevant to the record. He blew over that. He said, oh, well, I'll get to that. That's what I mean by blowing over it. Like, no, if the judge is pointing out state of contention over a matter, then that is your opportunity to shine. Not to be a jerk. And tell the judge, well, I don't want to talk about that right now. Basically, like, I don't want to talk about that right now. I don't think that's the most important thing. Well, what the fuck you thought was the most important thing in the court? Before the court, I mean, on this matter. And the judge trying to get him to help him by asking. They don't always ask questions to negate what you're saying. Sometimes they ask questions for you to better verbalize what your stance or your grounds are. And perhaps you may not be doing that good of a job of relaying that. Maybe you didn't do that good of a job of relaying that in your brief. And so they want you to clarify for the record in your oral argument. It's the time to do that. Let's move right along.
The accelerator pedal was frayed on the truck. He put it in reverse, ran over somebody and killed him. He did what we did. All we did was mail contracts to people that they
said he did what we did. Now, right after he said that man killed somebody. Y'all heard that on the record, right? Okay, I'm gonna run it back for you. Hold on, I'm gonna point out something. This. I don't know if he noticed. This sounds crazy as hell. Watch this.
The conviction, according to Rule 14.
Remind me again who Lee Cromwell is.
Lee Cromwell he was involved, during this time, he was involved in a vehicular homicide in East Tennessee. The accelerator pedal was frayed on the truck. He put it in reverse, ran over somebody and killed him. He did what we did. All we did was mail contracts to people that they acquiesced to because they didn't rebut the contract.
Okay, now, here we go. He's going all the way off the rails, bless his heart. He says he thinks the judges is his friends, I reckon. He done forgot he's supposed to be arguing the case. But right after he said the man killed somebody, his very next words was, and we did the same thing he did. That sounds like he was saying, we killed somebody, but it ain't no big deal. Let's brush right on past that. We all killed somebody. But that ain't what he's saying. He didn't say he wasn't trying to say that he also killed somebody. That he vehicle homicided somebody. He didn't say he wasn't trying to say he vehicle homicided nobody. He's trying to say that case isn't before the court, which he shouldn't have mentioned it in the first place. He talked too much, first of all. He talked about details that he don't understand can be used against him. He's just talking when that's not what court is for. That's not your YouTube channel. It's a court, baby. It's not your YouTube channel where you can just ramble on and tell people, just make accusations and tell people whatever's on your mind. And people even do that on YouTube, and with the risk of the liability that they may say something defamatory or slanderous. I believe even in this oral argument, he came very close to slanderous statements. Still lying. When he said that they all committed perjury. He should have said, made it clear what qualified as his determining factor that perjury was committed, which is pretty much irrelevant to this case. Again, some irrelevant facts. They may have committed perjury, but it's irrelevant to what he has before court right now. Okay, currently. Moving right along.
That's where this comes in at. Now, we didn't file any liens. We took the UCC1 filings and we sent them to the United States Treasury. The United States Treasury filed the liens. They used the IRS to collect the money. The IRS hit me with a frivolous filing twice. I beat it in court. I beat the IRS in court. And that was based on my ex-wife's bankruptcy. Tennessee said we had no legal basis to do what we did. The federal government agrees with us. The IRS, the tax court, and the Treasury all agree that we had genuine filings. The federal court in Greenville, my ex-wife came and testified against me. She said she had no debt with me. And then she did that at the trial in April of 18. By December of 18, she was filing the $4 million debt in bankruptcy. Okay? And by doing that, Title 11, United States Code, Section 532, subsection A2, says of the section where bar discharge only where bankrupt has actual knowledge of falsity of the statement or reckless disregard for the truth. She testified that she had no debt with me, took it to bankruptcy, scheduled it. The federal court discharged it. Only provable debts can be discharged in bankruptcy. You cannot take a fraudulent debt into bankruptcy and have it discharged. The judgment, I'm going to move on to the judgment orders. Judgment orders, I'm sure you're all familiar with. Judgment orders happen after the judge does the sentencing. And the Tennessee Constitution, per Article 6, Section 12, it says all writs and other processes shall run in the name of the state of Tennessee and bear test and be signed by the respective clerks. There's allegedly, well, I've seen them now, but there's 42 judgment sheets that haven't been filed. Those judgment sheets is when your time starts. This is when your time starts. The date on this is when you was tried. The Constitution says that they have to be stamped, filed, and signed by the clerk. If you look at the indictment was initialed by someone named KT. It's not signed. Okay? None of the judgment orders were stamped and filed per Rule 60.02 and the Tennessee Constitution, Article 6, Section 12. Since the judgment orders cannot be corrected per rule, the judgment orders are void. See also Rule 12, B-E, or Bravo Echo, and Rule B-2 of the Tennessee Rules of Criminal Procedure. For that matter, the indictment from the grand juries were not signed respectively by the clerks. At the jury trial, I already explained this. According to that, that's Birmingham, Title 11, United States Code, Section 533, subsection A2. That's Birmingham Trust National Bank versus Case. Title 11, United States Code, see Section 532, Note 341, Paragraph 15. A bankrupt is just discharged from provable debt if they are scheduled, properly scheduled. Okay? My ex-wife testified in court that she had no debt with me. That's in the transcripts. Turned around 9 months later and scheduled this in bankruptcy. Why didn't she do like the public officials did? Go to the state secretary because of the new law that was created because of what we did that year and have him removed. Because it's for public officials, right? The lien, we didn't lien anybody. And there's 3 federal agencies agreeing that our liens are valid. What I did is what we did was send a contract to the Treasury. The Secretary of the Treasury at the time was Jacob Lew. Here's $204 million in lien securities. These are yours. If you can collect them, you get 35%. You don't think the Treasury is going to want 35% of $200 million?
Wait now. Wait. Man, I don't know how he figured he could contract with these people to make them pay him this money or whatever like that, you know. Okay, I don't know what grounds and basis that he think he can do that. I couldn't even begin to tell you. First of of all, place a lien on somebody, you got procedures, proper procedures to do that, okay? If he tried to circumvent the procedures, and he submitted the obligation as what do you call that? To leverage, to get money. And so they gave him the money, but they also froze the accounts, I believe, all right, afterwards, after the casings, got going. He just said, and I don't know if you all heard what he said or not. We're going to run it back. But he just said, we didn't lien nobody. But then he said the U.S. Treasury deemed their liens to be valid. So did you lien somebody, or did you not? Did you lien somebody and it was valid, or did you not lien somebody? All right. Oh, that's his own, by his own admission, he's saying our liens. So he's now referring to the contracts as liens, when he should have maintained that they were contracts with a lawful obligation that he could legally collect on, okay? Due to the postal rule and effectiveness of the contract and so forth. But he called them liens himself on the record. I don't know how much attention the judges have given to that fact, because they didn't say anything. But like I said, they're just listening to him, and they probably hoping he'll say something on the record that they can hold against him. So they want him to keep on, just keep running your mouth. You gonna fuck up and say something you don't got no business, and then we got you, and this is one of those things where he's saying, oh no, I have a lien. The liens are valid. Even the U.S. Treasury said the liens were valid. And I contested the frivolous filing, the frivolous claims filing by the IRS and won, okay? Because the contracts were confirmed to be enforceable, okay? And because I don't think he's understanding that the law, or the rules to perform a collection process. So he's not understanding that the lien itself is not the collection of the debt. The lien itself is a notice of obligation. Okay, it's just a notice on the record that, okay, these people owe me money, and he filed the UCC apparently, and placed the courts on notice that these people who I'm in a contract with under this contract license, this contract transaction number. That's his receipts for his certified letters, and he simultaneously used that as his contract identifier. Okay, and so he used that number to identify the obligation and isolate the obligation under the postal rule. Okay. However, I don't think he gave proper time to cure or allowed the people to counteroffer in any way so that they can reach a meeting of the minds. Perhaps those big people, if they knew anything about contracting in that way, they might have agreed. They're greedy, they want money too. Shit, they probably like, okay, what do I do? And he probably could have walked them through whatever it was they needed to do on their end in the private. Okay, because these are contracts in the private. This is the reason why in the opening statement when he mentioned the exhibit, he said that the exhibit was available for review only. And so he's placing some boundaries of protection on his intellectual property and protecting and reserving his rights to privacy, to contract in private, okay? But all of his stuff is before the court now, that he had to bring this case and claim to court. And apparently he has another federal case that he's already made a claim, a 1983 claim, I think, against them. So this is probably like one of the steps. Okay, they may say, did you seek relief through this court, or did you seek relief through that option, before you bring your case to the higher courts. They want to know that did you seek to handle it below.
And we had a combined amount of almost $2 billion in lien securities.
$2 billion?
The federal government has agreed with what we did. In closing, we were picked up on February the 17th, or February the 15th of 2017. I was told there was a warrant. I asked for the warrant. Oh, we'll show it to you when we question you. Never seen a warrant. Took me down, read me the rights, took us all to Nashville, where they said there was an indictment. I've never seen an indictment until I was released and went to Emma Tennant's office and seen the actual case. 2 weeks later, they had us in Blackburn's court, where I challenged a jurisdiction. We all did. You can't proceed until you answer the challenge. She said, these are some serious charges. How do you plead? I said, I don't. Why? Murder's a serious charge. Rape's a serious charge. Child molestation is a serious charge. And you do not want to go to prison for that.
Why would he say that in the court? That was not even...
So where's the nature and cause? How do you plead? I don't. Well, I'm going to plead for you. You know you can't practice law from the bench. If she's a judge making a plea for me, she's saying she's my counsel, which we never seen. The whole 15 months I was locked up in Davidson County Jail, I never talked to an attorney. Never gave any attorney any power of attorney. They had a trial that lasted 5 days. The judge said, you can come in, but you'll not be allowed to say anything. Where's the Sixth Amendment in that? To this day, Tennessee has yet to put a single piece of paper in my hand saying they had the right to do anything that they did. And they interfered with the obligation of our contract.
Before your time runs out, this is a post-conviction relief petition, and almost everything I've heard has to do with a direct appeal. What post-conviction relief are you seeking, and what are you claiming entitles you to post-conviction relief?
We deserve post-conviction relief. Blackburn's gone. She's retired. We deserve to finally be heard. We've never been heard. If you take someone and you hold them using unlawful force, that's kidnapping. I was sexually assaulted by a guard in Davidson County, and I reported it, and no cop ever came and took my testimony.
All right.
You understand where this is at?
No.
We deserve to be heard. We, the people, Article 1, Section 1, have the right to abolish, reform, alter, or abolish the government in any manner we think proper.
Off the rails now.
That's why I say I'm not here pro se.
All right. Thank you, Mr. Hauser.
Thank you very much, and I hope you consider. Like I said, I'm only doing this because you guys have never heard that our due process was violated. Never heard it. Now you have, and now we can go to the federal courts and do a 1983. Thank you very much for y'all's day.
Right. General.
Wow.
Good morning, Your Honors. May it please the court. Liz Evan on behalf of the state. The only issue that's properly before the court today is whether this petition was timely, and it was not. There is no tolling provision that applies statutorily, and as far as due process tolling, it has to be some kind of event that's beyond the petitioner's control. And notably here, Davidson County Criminal Court Local Rule 6 allows for e-filing. He could have walked it over and handed it in the proper time. None of these things were done, and so therefore it simply was untimely, which is a strict jurisdictional bar. And Judge Holloway, you're correct that the vast majority of the allegations in the petition could have or were raised on direct appeal, so they're not even colorable. Potentially, he might have an ineffective assistance claim, if he were appointed counsel and that was fleshed out. But that only comes if the petition itself is timely filed, and this was not. I'm not going to belabor the point because I know it's been a long morning, but I'm happy to entertain questions from the panel.
No question. He didn't raise on top of issue.
Okay. We would ask that you affirm.
All right. Thank you, General. All right. That completes the morning docket. We'll be in recess till 1:30.
All rise.
Y'all follow YouTube and watch the video. There's 10,000 on the first one.
Wow, they're like, what the fuck? Wow. He is acting special needs like a motherfucker up in this courtroom. You can't do that. If you wanted to be heard, why you took so goddamn long to file your whatever you got going on, and then he got a direct appeal. And then he must have filed a side case for post judgment relief. And apparently he must not know what the rules is for post-judgment, to properly present a case for post-judgment relief. You know what? I don't either, okay? So we're gonna look that up and see what can you do after they screw over you, okay? What can you do besides the 1983?
Good morning, Your Honors.
Good morning.
and may it please the court.
Thank you all for the